Hi, good morning. Today we are going to analyze one problem question on covenants. There are three special covenants in this case, and we are going to analyze it. The video content has been made available for informational and educational purpose only. Kindly go through the disclaimer completely. Problem question. Imran is considered buying the wreck, a piece of land located in the center of Weatherfield. The wreck is a disused playground. Audrey is currently its registered proprietor. She purchased it from Rita in 1985, who at that time was also the registered freehold owner of the adjoining newsagent shop, the cabin. When Rita died in 2010, she left the cabin in her will to Mavis. When Mavis retired in 2017, she sold the cabin to Norris. Imran has discovered a deed dating from 1985 when Adbury acquired the wreck. It contained two covenants for the benefit of the neighboring premises. The covenants are Class A to keep the wreck free from the buildings and other structures. Class B not to let the line of shrubs planted between the wreck and cabin exceed 2 meters in height. The deed contained a further provision, Class C. It states that covenants in Class A and Class B will not benefit any subsequent purchaser of the benefited land unless the benefit is expressly assigned to them. Imran is planning on building a house on the wreck. To protect its privacy, he intends letting the shrubs between wreck and the cabin grow at least 3 meters in height. Imran therefore wants to know if he were to occur the wreck, whether the covenants in class A and B would be binding on him. We have to advise Imran. Class A to keep the wreck free from the buildings and other structures. The nature of the covenant is restrictive, a negative covenant, because it prohibits the erection of building or the structures on the land. So, how we are going to enforce the enforceability of the burden? According to 12 verses Mokshai, the burden of the restrictive covenant can pass in equity to successor and title if the covenant is negative in nature, it touches and concerns the land, the community retain the land that benefit from the covenant. It was intended to run with the land, the successor in title as the notice of covenant. So the Class A meet these requirements, suggesting that if the wreck is purchased, Imran could be bound by the covenant in equity. However, the 1985 deed states that the covenant benefit would not pass unless expressly assigned, which aligns with the ruling in Roque versus Chada and Crest Nicholson versus McAllister, confirming that the statutory annexation under the section 78 of LPA 1925 is excluded. Therefore, unless there was an explicit assignment to Norris, the current owner of the cabin and Norris may not have the benefit to enforce the covenant. Class B, not to let the line of the shrubs planted between the wreck and the cabin exceed 2 meters in height. The nature of the covenant is a passive covenant because it occurs active performance, maintaining the height of the shrubs. Enforceable to the burden of positive covenants does not pass to the successor in title as established in Ashbury versus Earldom Corporations and reinforced in Roney versus Stephens. The reasoning is that the past covenants impose an obligation requiring the expenditure of money or effort which equity does not enforce against the successors. Therefore, if Imran purchased the wreck, he would not be bound by Class B as it is a past covenant. Imran can let the shrubs grow beyond 2 meters. The benefit to Norris, the current owner of the cabin, to determine if Norris can enforce the covenants, we need to assess whether the benefit has passed to him. The benefit of covenant can pass through the express assignment, annexation, or a building scheme. However, a Class C explicitly requires express assignment for the benefit to pass. Thus, if no express assignment occurred through Rita's will or the subsequent conveyances, the benefit might not have transferred to Norris. So the Federated Homes versus Mill Lodge property, the case suggests that statutory annexation might apply where the Section 78 LPA 1925 operates, but this is excluded by Class C. Analysis of Imran's situation, covenant enforceability, since Class C limits the benefits of the covenants to those who have been expressly assigned the benefit, Imran would not be able to enforce the rights from the covenants unless Mavis or the Noris had assigned them to him. Without such an assignment, he would not be bound by the covenants. A private of estate, even if the covenants were intent to run with the land, the lack of assignment means that Imran may not bound by them. Under the principle from Ashbury vs. Oldham Corporation 1885, the burdens does not pass automatically to successors unless specified. What are the potential outcomes? If Imran buys the wreck, he can likely proceed with his plan to build a house and allow the shrubs to grow beyond 2 meters, as the covenants would not bind him unless explicitly assigned to him. If the Mavis or the Noris had assigned the benefit of the covenants, he could be liable for any breach and he would need to comply with them. Benefit of covenants, transfer of benefit. For Norris to enforce this covenant, he must have the benefit. Under Federated Homes versus Mill Lodge property, the benefit can pass either through statutory annexation or assignment. The Class C of 1985 deed states that the benefit will not pass unless explicitly assigned, which complicate the matter. This suggests that benefit could not pass simply through statutory annexation, as seen in Roque versus Chada and Crash versus Crash Nicholson versus McAllister. However, there is a potential for an equitable assignment of the benefit from Rita to Mavis and then to Norris if it can be demonstrated that the original transfer include the covenant as part of the testamentary gift in accordance with Newton Abbott Cooperative Society Limited versus Williams and Treadgold Limited. Let's conclude. Class A, Imran could be subject to a restrictive covenant if the burden passes in equity, but whether Norris can enforce it depends on whether the benefit was expressly assigned to him. Imran should investigate the chain of title and any assignment to determine the enforceability. Class B, Imran would not be bound by the past covenant and he can proceed with his plans to grow the shrubs taller. Norris right, Norris may not be able to enforce either covenant against Imran unless the benefit has been assigned explicitly, which seems unlikely given the language in the Class C. Imran should avoid entering into an indemnity provisions during the purchase, which might indirectly enforce the burden of the Class B. Additionally, he should consider whether Hansel versus Brussels mutual benefit case and the burden principle applies here. Although it is unlikely, given the separate nature of the benefits and burden in this scenario. Thank you.